Appeals. We're delighted to be back and delighted to have all of you back here in the courtroom. I'd like to introduce your panel. To my right, Judge Armstrong from Shelby County. To my left, Judge McGee from Savannah, and I'm Judge Golden from Memphis. It does feel good to be back, and we look forward to hearing your arguments today. Any messages or anything we need to discuss?
No, Your Honor.
All right, you may call the first case.
Sarah Boren versus David Wade, Jr.
Appellant ready?
May I begin?
May proceed.
Good afternoon. May it please the court. Abigail Hall from the Memphis Bar. May I reserve 2 minutes for rebuttal?
2 minutes?
Yes, Your Honor.
All right.
I represent the appellant's father, Mr. David Wade, Jr., and I will be referring to him as father throughout the course of my argument. This matter also involves the appellee, Ms. Sarah Boren, who I will be referring to as mother, and the party's 17-year-old daughter, Madeline. Today, we will be discussing one of the most important rights protected by our state and federal constitutions, the right to parent as one sees fit. Ultimately, this case begs the question, how far is too far for a court to go when interfering with a parent-child relationship? Today, I will show you that the trial court in this case went too far and essentially terminated father's parental rights by denying him all forms of meaningful access to his child for an indefinite period of time. The trial court failed in 3 ways. The first failure was finding that a material change in circumstance existed which affected Madeline's best interests such that a reduction in father's parenting time was warranted. The second issue is that the court wholly failed to analyze the relevant best interest factors prior to modifying father's parenting time. Lastly, and most significantly, the court failed both father and Madeline by suspending father's parenting time pending the completion of a Rule 35 psychological evaluation, a diagnosis being made, a treatment plan being developed, and father adhering to all recommended steps set forth in said treatment plan. A very brief history: the parties divorced in November of 2007. At the time, Madeline was 3 years old. When they divorced, a permanent parenting plan was entered which provided for equal parenting time, joint decision making. Since that time, several petitions were filed, various orders entered. Notably, father was ordered to undergo a psychological evaluation in May of 2010, which he did. An amended permanent parenting plan was entered in October 2010, awarding father 104 days of parenting time, and that amended permanent parenting plan was further modified in January of 2020. Father was awarded every other weekend parenting time with Madeline to correspond with the periods of time he had his son. Subsequent to that January 2020 order, several petitions and motions were filed, and the hearing at issue took place in August of 2020. On October 12, 2020, the court entered its order where it de facto terminated Mr. Wade's parental rights. He appealed. The first failure...
You used the term terminate his parental rights, but he didn't terminate his rights, did he?
It was, in effect, a termination. He was denied all access to his child for an indefinite period of time. No ability to see her, not supervised, not in the presence of a therapist. It was, in effect, a termination of their physical relationship with each other.
Okay.
The first failure of the court, as I mentioned, was finding that a material change in circumstance existed. At the time of trial, Madeline was thriving. The testimony was that she was enrolled in AP History, Honors Chemistry, Honors English, was a straight-A student. The court even noted in its own order, Madeline has, quote, not done one single bad thing during the entire time she has been at SBA, the school where she's enrolled. Madeline and her father were receiving counseling from Dr. Tenniswood. Father testified that the services were helping their relationship. The counseling was working. Madeline's principal testified that Madeline had never had any conduct issues at school. There was no testimony that established Madeline was exhibiting any signs that would indicate she was being harmed, emotionally or otherwise, by father. Mother, in her brief, alleges that Madeline was suffering, quote, increasing emotional harm and severe emotional upset. That is not supported by citation to the record. There was no expert testimony offered that Madeline was suffering from a emotional upset. There was no expert testimony that Madeline was suffering from a, quote, pattern of emotional abuse, as also referenced by Mother in her brief. There was no testimony that Father was suffering from, quote, emotional instability or experiencing, quote, erratic behavior by an expert in Mother's brief. These allegations levied by Mother are simply not supported. If a material change in circumstance did exist affecting Madeline's best interest, it would be at the hands of Mother, who had taken extraordinary measures to alienate Madeline from her father. Mother instilled unfounded fear in Madeline of her father. Mother manipulated Madeline into believing it was necessary for them to have codes. Text me 911 in the event you become scared. That was unnecessary. Mother testified that in the over 10 years since the parties' divorce, Madeline had never been physically hurt while with her father. This also manifested in Mother informing Madeline of an email generated by Father and sent to other adults. The email ultimately became a focal point of this litigation. The email was never intended to be viewed by children or shared with children, and Mother's decision to do so was an attempt to undermine the relationship between Father and Madeline again. Mother's decision to inform Madeline of this email rises to the level of an intentional act at parental alienation, and this court has held in McLean versus McLean that parental alienation on its face may rise to the level of a material change in circumstance. Father submits that as a result of this change at Mother's hands, his parenting time should be expanded, not limited, in order to protect and preserve Madeline's best interests. The second issue in the court is that the court wholly failed to analyze the relevant best interest factors prior to cutting off all of Father's access to Madeline. The trial court, although made mention of Madeline's well-being, did not perform the requisite best interest analysis, nor did it specifically list any best interest factors that might be implicated in this matter. This is analogous to the case of Moore v. Moore, wherein the trial court made some best interest findings, however, did not relate those findings to any best interest factor. As a result, this court vacated the trial court's modification of the parenting plan and remanded the case for a determination of what was in the child's best interest. Mother submits the trial court did account for Madeline's best interest when it suspended Father's parenting time pending the Rule 35. And Mother's brief is written in such a way that could mislead the court by asserting that the trial court performed the analysis provided pursuant to 36-6406. However, that is not the case. 36-6406 requires a finding that a parent's conduct may have an adverse effect on the child's best interest, and the court may then preclude or limit the parent's parenting time if one or more of the enumerated factors are found to exist after a hearing. The trial court's order does not reference 36-6406, nor does it point to which specific enumerated factor is applicable. As such, the court failed to complete the best interest analysis pursuant to 36-406, pursuant to 36-6106, or otherwise. If the court had properly conducted a best interest analysis pursuant to the applicable statutes, Father submits it would have warranted an expansion of his parenting time. Lastly, and most significantly, the court failed both Father and Madeline by suspending Father's parenting time pending the completion of the Rule 35 evaluation, a diagnosis being made, a treatment plan being developed, and Father adhering to all recommended steps set forth in the treatment plan. This is critical. 36-6301 only allows for a prohibition on visitation in the event that the court finds the non-custodial parent has physically or emotionally abused the child. There was no finding of abuse by the trial court. 36-6301 requires the court to grant such rights of visitation as will enable a child and non-custodial parent to maintain a parent-child relationship unless the court finds after a hearing the visitation is likely to endanger the child's physical or emotional health. There was no evidence that visitation with Father would jeopardize Madeline's physical or moral sense. In fact, on cross-examination, even after having learned of the email that was circulated that was such an issue in this matter, Madeline's principal acknowledged that since that email, she had not witnessed Madeline suffer at all. This turns on what is reasonable in light of the specific facts, and a complete bar on father from being able to access Madeline is not reasonable under the circumstances or permissible under the law. Even if the court found that visitation with father was likely to endanger Madeline's physical or emotional health, the court is required to craft an order that incorporates the least restrictive means permissible, which could include supervised visitation, parent-child counseling, or any other number of options available to the court. The case law is clear. Courts must strive to devise custody arrangements that promote the development of a child's relationship with both parents and should interfere as little as possible with post-divorce family decision-making. Further, it's the public policy of the state of Tennessee that courts shall grant parenting time with the non-custodial parent unless visitation will harm the child. To interfere with the non-custodial parent's ability to maintain a parent-child relationship due to visitation endangering the child's physical and moral sense requires definite evidence. There was no finding by the trial court that visitation with father would jeopardize Madeline. This is analogous to Kershaw versus Kershaw. In the matter of Kershaw, the court held that the trial court made no findings that the actions of mother, although egregious, in any way jeopardized the children, and therefore there was no legal basis to suspend mother's parenting time. We submit the same is true here. The trial court made no findings that the actions of father jeopardized Madeline, and therefore there was no legal basis to suspend father's parenting time. Nothing in the trial court's order promotes the parent-child relationship, and the benchmarks that father must satisfy in order to even attempt to lift the suspension of his parenting time are all but impossible to meet. Before father could attempt to remove the suspension of his parenting time, it is contingent upon him undergoing a Rule 35 psych eval, being diagnosed, contingent upon a treatment plan being established, and contingent upon father complying with all recommendations of the treatment plan. The trial court assumes that a diagnosis is inevitable and doesn't account for what happens in the event that the Rule 35 psych eval doesn't result in a diagnosis. The trial court assumes that a treatment plan is necessary, does not provide for what happens in the event a treatment plan is not needed. Further, the trial court does not provide for what happens in the event that a treatment plan, if established, does not comport with other treatments father may be receiving from other health care providers. Mother cites to the Whitaker case, presumably to demonstrate that withholding visitation rights from a parent, unless and until they complete certain actions, can be considered a reasonable condition on parenting time. However, it must be noted that this court in the Whitaker matter, in fact, modified the trial court's final decree to apply a less restrictive condition, same as we are asking the court to do here today. Another issue that was raised at the trial court was the appointment of Dr. Bailey as the Rule 35 professional to perform the analysis. Father has concerns regarding Dr. Bailey's neutrality. His concerns are not without support, as this is a unique matter given that father's father is a well-known attorney in Shelby County, and further that father's father is paying, at some level, mother's attorney fees and the fees of the guardian ad litem, which are the individuals who selected Dr. Bailey or recommended Dr. Bailey to the court. Father raises the issue of attorney fees in his brief. He submits that the award of attorney fees to mother at trial was improper, believes he should have been awarded costs in the underlying action, and seeks an award of fees and costs associated with this appeal. Your Honors, when a court fails to adhere to applicable laws concerning parental rights and those laws intended to protect the relationship shared between parents and their children, it can have the practical effect of terminating a parent's rights, as has happened here, and that is supported by the case law. It is outlined as an outcome in Allen versus Allen and Melvin versus Mallon. The trial court described its ruling as a, quote, non-punitive pause on father's parenting time. However, father is not aware of any more punitive action that could have been taken by the court than this de facto termination of his rights. He hasn't seen his child in 2 years. He's requesting that this court vacate the trial court's order dated October 12, 2020, and reinstate the parenting time as was previously ordered by the court.
Let me ask you, Ms. Paul, is a transcript of the in-camera examination by the trial court in the record for our review?
Of the interview of the child?
Yes.
I don't believe so, Your Honor.
Okay.
I think you'll have your rebuttal time.
Thank you.
My voice is a little bit impaired. Good afternoon, Your Honors. I, along with Sims Bobo, my associate, represent Sarah Boren in this matter.
Did you introduce yourself? I'm sorry.
I'm sorry, Your Honor. Charles McGee. I'm Charles McGee from the Memphis Bar, and I represent Sarah Boren in this matter. I would first like to give the court some foundation of this proceeding. Judge Stokes has been hearing matters on this case for 10 years. If you look at the appellant's brief, it cites a litany of issues that have been filed by Mr. Wade in this matter. It's a continuous, ongoing litigation in this case. In December of 2020, Judge Stokes suspended his visitation for very similar conduct that's occurred in this subsequent hearing. He was submitting filthy, salacious emails that were being directed at all the parents, all the faculty of the school, the principal, and affecting the minor child as a result of that. After 60 days, he was allowed to repetition the court, which he did. After that, another petition had to be filed by mother in order to address the same problems that were ongoing. I submit to the court that Judge Stokes went in detail in an 8-page findings of fact as to what Mr. Wade had done to merit such a restriction on his visitation. And I would like to point out one other thing, Your Honor. The Rule 35, if he had subjected himself to it, would have been completed in 30 to 90 days. What he has chosen to do for the last 23 months is nothing. He has attempted to do nothing. He has appealed the record instead of the ruling instead of complying with the court's order. The court, they raised the issue of it does not address if he did not have a diagnosis. I submit to court that common sense said if you don't have a diagnosis, you don't have a treatment plan, you don't have a duty to comply with the treatment plan. If you have a diagnosis, then those conditions exist in order to protect the best interest of the minor child. I think one of the important witnesses was the principal of SBA. She in detail testified to the court what the school had been receiving as emails directed at the school, the principals, the teachers, and what was the effect of all that? The effect, what she testified to, was the child was being singled out by students and peers and being made fun of. In addition, she was the teachers were going to not allow her, that's incorrect, they were going to ask the principal not to assign this child to the class that she would be available for advanced classes, because the teachers did not want the wrath of Mr. Wade directed toward them. Mr. Wade has been on a constant terror in attacking the school, affecting the minor child. The court did bring out a very important point, and I do not know if the transcript of the interview was included in this brief, but there's testimony from statements from Judge.
I'm sorry, you don't know whether the transcript is in the record? Is that?
Correct. I did not submit that record. It was submitted by the appellant. But what he did say in this, as part of the case, is Ms. Zacharias, who was the guardian ad litem, let me thank you before I close by being persistent that I hear from Madeline. I'm glad I did. I spent about 45 minutes with her, and I got some sense of what she feels. I get it, but it's not enough for me to get it. I want you to get it, Mr. Wade. I want you to get it. How could you not get it? I spent 45 minutes with her and sensed that what she's going through. You're her father. You spent all this time with her. You still didn't get it. But maybe you will. The court acknowledged that father has exercised good judgment in one situation where he allowed Madeline to go to Florida on a trip with her mother. I think that gives an indication of what the court thought of Madeline's testimony. It was.
Sorry, Mr. McGee, how do we review that if there's no transcript of that in-camera examination in the record?
Here is the point being, and the court did put restrictions on all of us. He did not want to interview the child, and that's why he's thanking Lisa Zacharias and how helpful it was. Subsequent to that, he allowed counsel and Mr. Wade, who was representing himself, to read the interview of the minor child. He sealed the record at that point in time, and none of us were allowed to keep copies of it. And so after that, this was with the statement that Judge Stokes came out and said as it relates to what his interview.
All right, and that statement refers to what factor that the trial court is required to consider?
The emotional effect of the minor child, the psychological effect on the minor child of dad's conduct. There is another incident where the child, they brought this up, the 911 text. The 911 text resulted from Mr. Wade screaming at his daughter. She's crying uncontrollably, sitting down in front of her, reading a Bible, threatening, not threatening, but making statements about what he thought they were doing wrong. And what created this confrontation? She was there with her brother. They were sitting on the couch, and he told them they needed to be doing something else, reading or something of that effect, and then he went and had this tirade. What happened next was interesting. The son ran to get a neighbor who he didn't know. They were living in a complex. The neighbor came down there because of the fear of the son and asked Mr. Wade, was there anything wrong? At which she said no. The police showed up, and after the investigation, both children were given back to both mothers to spend the rest of the time with their own mothers instead of Mr. Wade's parenting time. He has specifically, I think, a lot of what Judge Stokes says, and he says it in his findings. What occurred during the week before the trial started was exactly what he had been told not to do, and that was not to issue on social media or emails any comments about the school that would affect Madeline and not. He even did this during the trial, in which he submitted an 11-page email and 100 attachments talking about salacious, filthy conduct that Judge Stokes found to be unacceptable. And so the previous psychological evaluation that they have referred to did make a finding. I don't believe it's proper for me to state what that finding was, but did make a finding on the results of that evaluation.
So that report is also not in the record, Mr. McGee?
I believe it is, Your Honor. I would have to go back. There's 100, I believe, exhibits on this, and it was referred to by the judge during the trial. And so I don't know if he absolutely reviewed it, because here was the problem. The admissibility of that document was difficult, if not impossible, based upon Dr. Steinberg, who did the report, having passed away. And therefore, obtaining the ability to get past the hearsay rule of that report was a difficult, if not impossible, manner to deal with that issue. I apologize.
Was there a dispute concerning the contents of the 2010 Rule 35 examination?
Well, I think the dispute only was that Mr. Wade thought it was inaccurate. And that was I submit to the court, that's why he does not want to take this Rule 35 examination. I believe there is ample proof in the record for the court to do that. And the court took a non-punitive measure. If you take the Rule 35, we'll have another hearing. If you have issues, we'll set out a plan. If not, then obviously there's no reason to have a plan for this. I'm baffled by why Mr. Wade would not do that in order that he be allowed to have his visitation reinstated under whatever the circumstances are. And he's the architect of his own lack of being able to see his daughter for the last 23 months. And I submit to the court that the court did make specific findings of fact as it relates to the best interest of the child. And he specifically says,
But you have to concede, though, that there's no reference to the statutory factors in the order, don't you?
I do, Your Honor, but I do not believe, and I believe the case law reflects it. You don't have to go through a standard on each one. I mean, if that were true, if you just say this is significant emotional abuse or psychological abuse, I'm not sure why you had to find out that this other is equal, this is equal. If that one is determined to be the controlling factor and in the best interest of the child, then the court does not have to do an analysis unless this court cannot determine what that basis was. And I submit to the court that the 8-page ruling gives this court all of the basis that has. This child, if you read the ruling, it also indicates that the other effect of Mr. Wade's incessant conduct was this child was very close to being thrown out of SBA by the principal. She testified that. And what they refer to as her being an A student, all that was correct. And that was stated in the testimony of the principal, was that Madeline was not the problem. Who was the problem was her father. Her father was the reason that he was they were considering expelling her from the school in her senior year, which Principal Morris testified could have a negative effect on her applications to colleges and any admissions requirement. So there's a combination of so many factors that she is being subjected to, and she is being psychologically abused. I submit to the court, the record is replete with all of the conduct that Mr. Wade has conducted. I'll briefly address the other issues. The Rule 35 argument, and very succinctly, is David Wade Sr. has influence over the medical community because he's a highly respected lawyer, and therefore his contacts in the medical community may influence any of the psychologists here in town.
Any showing in the record that Mr. Wade Sr. even Knows Dr. Bailey?
There is no showing in the record that there is any correlation between Dr. Bailey and any contact with David Wade Sr. There is just this generalized statement that that is why he does not want to go to Dr. Bailey. Judge Stokes is the appointing party, appointed Dr. Bailey. It was not selected by either party or the guardian ad litem. Recommendations were made, and then Judge Stokes made the appointment. And so I submit to the court that there is a replete evidence in this matter to show that a material change of circumstances has occurred and it is the best interest of the child to remain in the custody of the mother until Mr. Wade completes his Rule 35. Thank you, Your Honor.
Thank you. Ms. Hall?
So let me ask you, there are a number of findings in the trial court's order. Why is that not sufficient for us to review and make our own comparison to those findings to the relevant statutory factors?
Sure. The reason why that is not going to be sufficient for y'all to review the order and then make your own determination as to what factor the court was speaking to and how that factor favored one or the other parent is that 36301, which is the statute that provides for a prohibition on visitation in the event that the court finds the non-custodial parent, requires the finding of physical or emotional abuse. There is no such finding in that order, and therefore no best interest analysis can support what the court did in this case. Mother makes it sound so simple. Father, you could have undergone the Rule 35 in 30 to 90 days and be done with this. Pursuant to Judge Stokes' order, it does not stop there. He would have had to have been diagnosed, as the order reads. It reads plainly on its face. He would have had to develop a treatment plan with the Rule 35 evaluator. He would have had to have followed the recommendations of that treatment plan. Well, if the recommendation was participate in 24 months worth of counseling, that is an untenable result to him being able to be reunited with his child.
Has the child graduated from high school?
She's in her senior year, so she'll graduate.
sorry?
She's in her senior year as we sit today, is my understanding, so she'll graduate in May 20.
May of next year.
Yes,
Okay.
that's my understanding. That is not in the record, as I recall.
And the child turns 18 when?
December of this year. December of 2022.
Suppose there was no diagnosis. Suppose he took the examination and the doctor said, there's no problem here. Then, isn't that the way you find out, is by having the examination?
I suspect then, yes, he would have gone back to the court and said, all clear, can I please be reunited? But if it did yield a diagnosis, it would have triggered this never-ending, no end in sight timeline of things that he had to comply with.
But you don't know because he didn't go take the exam.
We don't know because he did not take this Rule 35. However, the court had the benefit of reviewing the Rule 35 that he underwent in 2010. And I can say briefly, Mother talks about teachers testifying to not wanting Madeline in their class. Not one teacher testified at the trial. The principal made an alluded statement that was objected to. The objection was sustained. This email, again, sent to adults. Fathers should not be punished because other adults chose to share that email with children. That was poor decision-making on the part of those adults. Father did no such thing.
How many adults was that email sent to?
I believe the testimony as a trial was never confirmed a number. Certainly it was sent to a significant number of contacts in and around Mr. Wade's close circle of friends and supporters, people who have an interest in what's going on at that school, but it was never intended to be shared with children.
Didn't the judge's order, maybe I misread this, maybe 4,000?
He has that many Facebook friends, I think was the testimony at trial.
And so if he posted that on Facebook, then those 4,000 may have looked at it and they may have shared it with others.
Correct. If he posted an email or any post to Facebook, certainly I think his followers or friends may have been able to view it. He is not precluded from speaking. He has a right to free speech, and if he believes children are being injured or subject to being injured, he should speak about that.
Even if it adversely affected his child at the school that she was attending, he thought he should do that?
He thinks that children should be protected, and he does not think that what he did adversely affected his child, and the proof doesn't demonstrate that it adversely affected his child. She was a great girl, is a great girl, great grades, great future.
Now, the examination, transcript of the in-camera examination is not in the record, but as I understand it, you read the transcript. Is there an indication in the transcript that the child is adversely affected?
I have not read that transcript. I was not representing Mr. Wade at that time, and I've never recovered a copy of that transcript, and I don't think any exist as we sit here today. I believe they were all, the transcripts of that in-camera interview were to be destroyed. But it is not a part of the record, as I'm aware.
Okay.
Thank you. I believe that's all my time.
Thank you for your argument. We'll endeavor to get you an opinion as soon as possible. May call the next case.
Eugene Moxley versus Amaso SFH Inc., DBA